We hope everyone is enjoying our snowy weather just before our temperatures begin to rise yet again. Today's topic is kind of interesting. It's still amazing to me that in 2017 we still are getting challenges as a profession and individual doctors, whether it be in denials for insurance coverage or whether it be for denials for lab work or whatever the case might be. But it's still amazing to me that we still have scope questions and issues that arise in those various areas. And so I wanted to arm you with a couple of different pieces of information. First of all, I want to talk about the Medical Practice Act and our definition there. And I also want to talk about some case law that actually has risen all the way to the Illinois Supreme Court and some of the language that we have really to deal with some of these issues and appeals that we may give and some discussions that we may have with those administrators that may be denying us the ability to recommend for lab work or for imaging or whatever the case might be. So first of all, let's hit the Medical Practice Act. I think it's quite clear in the Medical Practice Act that the term physician specifically includes chiropractic physicians. And then the term chiropractic physician really lays out this exact language. It says, chiropractic physician means a person licensed to treat human ailments without the use of drugs and without operative surgery. Nothing in this act shall be construed to prohibit a chiropractic physician from providing advice regarding the use of non-prescription products or from administering atmospheric oxygen. Nothing in this act shall be construed to authorize a chiropractic physician to prescribe drugs. So the beginning really kind of lays it out very clearly. Chiropractic physician means a person licensed to treat human ailments without the use of drugs and without operative surgery. We think that that's abundantly clear and it's very broad. There's only two exclusions, and that's prescription drugs and operative surgery. Now here's what's really cool is we actually have two Supreme Court cases. One actually predates the Illinois Chiropractic Society's 91-year history and was actually issued in 1924. It's People versus Witte, W-I-T-T-E. Again, 1924 Illinois Supreme Court. And this is the quote that they gave in their opinion. There is no distinction. Let me start again. There is no distinction between the two classes of practitioners as to the diseases which they may treat. Now see, the beauty in this is, and when somebody indicates that something is outside of your scope and it's not prescription drugs and it's not operative surgery, at this moment you not only have the backing of the Medical Practice Act, but also this particular Supreme Court case. And you can use this case to very clearly demonstrate the breadth of the ailments in which you can utilize and treat. Now, the second Supreme Court case is actually considerably more recent. It was in 2003, and it was Vanier versus Department of Professional Regulation. So this was just prior to Department of Professional Regulation becoming the Illinois Department of Financial and Professional Regulation. But it's Vanier versus Department of Regulation, Professional Regulation, and this was in the Illinois Supreme Court case. Under the law, this is a quote directly from the opinion again, under the law, those holding the degree of Doctor of Chiropractic possess precisely the same professional status as doctors of medicine or doctors of osteopathy. All are regarded as physicians. So this case very clearly indicates our status as it pertains to other physicians under the Medical Practice Act. We believe that those three things should arm you with great material as you begin to push back on systems that may be rejecting your referrals or on insurance companies that may be denying your claims because they indicate that something is out of scope. We encourage you to use all three of them in your rebuttals or in your appeals or in your discussions with those particular systems. You guys have a great week, and we'll talk to you probably a little later this week as as several of us are going to be in Washington, D.C. advocating on your behalf on the national level. We'll talk to you then.